Good morning, everyone. Thank you so much for joining us for Strengthening Community, Law, Policy, and Voluntary Associations. I'm Andy Smerick, and I'm a senior fellow here at the Manhattan Institute, and I'm going to be moderating today. In just a moment, I will introduce our three fantastic panelists. But first, I just wanted to explain why we're here, why this event is happening, and why the subject is so important. Now, it is sometimes said that government is simply the name we give to the things we do together. But that's not exactly right, is it? Government is a way for us to work collectively, but we can also come together outside of government in a lot of different ways. Voluntary associations, for example, are groups of people who come together of their own volition to solve a problem, to take advantage of some sort of opportunity, to worship, to build a community, to help neighbors or to seek help, to protest something, to preserve something, to start something up. Now, interestingly, like 200 years ago almost, Tocqueville wrote that America had this unusual proclivity for forming these kinds of groups. Americans back then and ever since didn't rely on aristocrats or the government to solve every problem. Instead, we found some neighbors and some friends, and we just got it done after getting together. Now, since then, America's landscape has been dotted with thousands and thousands and thousands of what President George H.W. Bush famously called points of light, clubs and churches and PTAs and shelters, charities, community groups, sports leagues, and on and on. These groups do lots of things that are obvious. They help rehab a playground. They can help hand out food to families that are in desperate need. But they also do things that are less visible, but equally important. They form us into better citizens, into better neighbors. They foster solidarity in our neighborhoods and communities. They enforce social norms. They pass on valuable traditions. And it's hard to overstate just how important these things are in America, especially in this moment. We are an extraordinarily diverse continental republic, unlike just about any other. And these associations enable us to preserve our particular cultures and histories and enable us to serve our communities. And as more and more power gravitates towards Washington or gigantic corporations, these groups give us a sense of place, a sense of security, a sense of meaning. They help us, each one of us actually, realize that we're more than a customer, more than just a data point, more than just one of 330 million people out there. But then the question becomes, what are the actual rights of these groups? Are they simply nice to have, or do they have a place in our constitutional order? Can government regulate them, their behavior, even their membership? What exactly is this freedom of assembly or freedom of association that are in or around our Constitution? And more broadly, for those of you who are interested in policymaking, the elected branches, what can and what should governments do to make sure that these groups can thrive? Grant programs, family supports, tax policy, something else? Well, we have the greatest panel possible, just an outstanding group of people to help us work through these issues, including something we're going to get to eventually, this important U.S. Supreme Court case that they just heard last week, I think, that may render the most important decision on the freedom of assembly and the freedom of association in 20, 30, maybe even 40 years. Okay, so first up is John Nazu. He is the Sally D. Danforth Distinguished Professor of Law and Religion and Professor of Political Science at Washington University in St. Louis. His scholarship focuses on the First Amendment, the freedoms of speech and assembly and religion, and he's the author of multiple books, including two of my very favorites on the subject, Liberty's Refuge and Confident Pluralism. Next up is Abby McCloskey. She is founder and principal of McCloskey Policy, a research and consulting firm that serves businesses and political leaders nationwide. She was previously a policy director for multiple presidential campaigns and the program director for economic policy at the American Enterprise Institute. She's written on many subjects, including the one we're here to talk about today, what role can policy play in strengthening community? And last but certainly not least, we have Luke Sheehan. He's an assistant professor of political science at Duquesne University and a non-resident scholar at the University of Pennsylvania program for research on religion and urban civil society. His work also focuses on the freedom of association, religious liberty, and academic freedom, and he's the author of the excellent book, Why Associations Matter. So just in terms of operations here, each presenter gets about 5 minutes or so. I don't have a clock on them. I just want them to be able to get started, say what they think is good to get this conversation going. Then I'm going to just ask some questions to see if I can get a freewheeling conversation going. But I should also say, for those watching, please send questions in using that chat function as early and as often as you would like. I like to get your responses into the bloodstream so this can be a responsive, interesting conversation to all of you watching. So enough of my talking. Professor Inazu, the floor is all yours. Thank you.
Andy, thanks so much. And it's great to join you and to have Luke and Abby here for this important discussion. I'm going to start us off with a few reflections on the right of assembly and begin with the First Amendment itself. Assembly is one of 5 individual rights in the First Amendment, the others being speech, press, petition, and religion. And it's the only one that requires more than one person to be exercised. In theory, at least, I can do all 4 of those other rights by myself. But the nature of assembly, by its very wording and meaning, requires at least one other person to assemble with me. And this is crucial to how we actually live in society. We live as groups of people that form our identities and help to shape our beliefs. And in fact, I would suggest that this understanding of groups and First Amendment rights is essential to our democratic health. Somewhat counterintuitively, we have to be able to find ways to protect our deepest differences if we're going to find common ground across those differences. And this is what I call confident pluralism. Early in our country's history, a lot of groups understood the right of assembly and these values that underlie it, including the anti-federalists, suffragists, abolitionists, the early labor movement, and we have cases and historical examples where the right of assembly was foregrounded in these efforts. There was, however, one challenge to all of this, and that was the wording of the Assembly Clause itself. The First Amendment refers to the right of the people peaceably to assemble, comma, and to petition the government for a redress of grievances. Now, the comma is likely a residual from earlier state formulations of these clauses, and the grammar did not obscure the intent. The intent was clear that assembly and petition were 2 different rights. But the Supreme Court, in a quirk of history in 1886, decided otherwise and wrote that assembly was only for the purposes of petitioning the government, in fact, collapsing those 2 rights into one. And that became significant because generations of scholars followed that interpretation. It's wrong textually, historically, and doctrinally, but it set a course in a different direction. Perhaps most significantly, when the Supreme Court first recognized the right of association in 1958, it looked back to that 1886 case, scholars and commentators referring to the 1958 decision, and said that the new associational right could not possibly be grounded in this narrow assembly to petition right. So instead, courts and commentators subsequent to 1958 looked to the speech right as the basis of association. And this ignores the relational dimensions of what associations are and what the right of assembly represents. There was then a further move as the court turned to protest cases. And in those cases, too, adopted a speech-based public forum analysis that also neglected the assembly roots of the public forum doctrine. And then in 1984, the Supreme Court doubled down on its erroneous interpretation and split the right of association into component parts, what it called intimate association and expressive association. Intimate association, it turns out, protects no actual groups that need protecting. It's limited mostly to close family members that find adequate protections elsewhere in the Constitution. Expressive association, the court's never been clear on its boundaries, its meaning, or even the constitutional framework to analyze the protections for expressive associations. And as Andy mentioned, just last week, the Supreme Court heard oral arguments in a case called Americans for Prosperity against Bonta that raises these problems with expressive association related to nonprofit donor disclosure laws. During his questioning in those oral arguments, Justice Kavanaugh, perhaps recognizing some of the problems with a speech-based expressive association framework, asked the question that the Supreme Court got wrong in 1886. Is the right of assembly distinct from the right to petition the government? Justices Barrett and Kagan then asked similar questions. Perhaps, and I'm hoping that these questions suggest the court will finally recover the forgotten right of assembly and rediscover the relational roots to both associational and protest protections. So with that, I look forward to the discussion to follow and hearing from Abby and Luke.
Well, that's fantastic. If I can just add a follow-up question just for clarification, because I think this is maybe the core of the issue. So when I read the language, the freedom of assembly, I think about a wide array of different organizations with different types of purposes. But if beginning in 1886, the view was no, assemblies are really about petitioning the government, or then later on, no, it's really about free speech rights, or no, it's about expressive association or intimate association, it raises this question of what about all of the associations out there that aren't about free speech, that aren't intimate, that aren't about expressive? Do they have any defenses, any protections at all? Is that about right, the kind of conversation we need to be having?
Yeah, that cuts to the core of some of these issues. And so to start with the court's current nomenclature and distinctions, if there are in fact these categories of associations that the court recognizes as neither intimate nor expressive, then what protections do they have at all? It turns out almost none. And there are lower courts that have then held that certain kinds of groups fall into that category. Perhaps most oddly, a motorcycle club was found to be non-expressive, even though their entire operation, their website, their jackets, their motto were expressing things. The Ninth Circuit found they weren't expressive and therefore entitled to no constitutional protection. So when we have courts and policymakers deciding which groups count as expressive and which groups don't, that leaves a wide array of groups in society virtually unprotected.
Terrific. Thank you. I'd like to go to Luke next, because I read your book, Luke, after reading some of John's. And what really struck me is how you brought in one of my favorite authors, Robert Nisbet, his ideas of community and what communities mean to citizens and mean to liberty. And I think, I don't want to put words in your mouth, but you had this idea of trying to provide a philosophical, political framework for some of the court's thinking. So let me just hand it off to you.
Thank you, Andy. Yes. I use the work of Robert Nisbet, a famous 20th century American sociologist, because I think he helps us think about what groups are and what they should be. And when we talk about the freedom of assembly, what we're talking about are groups, social groups, groups that form for a variety of purposes. So think about what John just said about free assemblies forming not to petition the government for a redress of grievances, but that clause is a standalone, peaceable assemblies. It doesn't give a purpose for why they would assemble. So the purposes they would assemble for, that apparently are protected by that clause, will be left up to the individuals who form them. And as John said, the assembly clause is the only one that's inherently relational. You ought to have somebody else that you're associating with in order to be practicing the right of assembly, or else you're just an individual on your own. But it's a really essential right if we want to understand the real meaning and purpose of the other rights. So take the free exercise clause. Many people are religious, and it's really important to them, their individual faith, that they be able to exercise their religion. Well, how do they do so? Well, maybe they pray on their own. Maybe they read their sacred scriptures on their own. But almost certainly, very core to the exercise of their religion is the aspect of assembly. That is, or the aspect of association. That is, doing it with others of like mind and like belief, embedding themselves into an institution and participating in that institution. Now, the court, as John just discussed, has not been very good on recognizing this right of assembly. It has defined it very, very narrowly. It's connected to the petition clause, and John has given all sorts of reasons why that's wrong across the board, jurisprudentially, historically, philosophically, and so on. Now, one question is, why did the court go that direction in its jurisprudence? Why did it take an associational right with its own independent clause, the assembly clause, and narrow it all the way down to this idea of expressive association? The reason I think that the court did that is what I call a philosophical framework that I call the First Amendment dichotomy. Here's what that is. When the court approaches the First Amendment, especially anything dealing with associational rights, it has a tendency to dichotomize its concerns into either the individual and the expressive right of individuals, or the importance of the practice of the right to the health of the democratic state. So take freedom of speech. freedom of speech as an individual right. We can all speak on our own. It's also, so it's an individual right, but it's also essential to the health of our democracy. That is that citizens talk to each other, that we work out our disagreements, we come to an agreement on who we want to represent us, on what policies we want, all of that. Absolutely essential. So when the court looks at associations, it understands them as benefiting the individual, that is by amplifying the individual voice. You join a group, an expressive association, to amplify your voice and participate in this democratic dialogue. And of course, the court is then seeing associations valuable insofar as they're helping the health of that democratic discourse. And you can deny that associations, expressive associations, do those things. However, as Andy and John just pointed out, it leaves out a vast swath of associations that are peaceable, but that aren't expressive. And they also aren't what we described as intimate, which is a very, very small subset of really family relationships. There's all sorts of associations out there. Think of fraternities, sororities, all various clubs you could be a part of, and meetings, and all of this that would not be really expressive. And lower courts have been pretty narrow on what it will consider expressive. The example John just gave about the motorcycle group, it leaves a lot of our civil society with virtually no constitutional protection unless you can prove and you can demonstrate in a court of law that you have some expressive purpose that's going to have some democratic ramifications. I think that's highly problematic. And instead, I think we should think about the First Amendment through a lens of what I call First Amendment pluralism. And what this means is there are concerns the state has in democracy, of course, and of course the individual has First Amendment rights, right of expression, religious belief, and so on. But we should also think about groups is operating in the First Amendment, associations operating in the First Amendment, to establish something like what that famous sociologist Robert Nisbet called a laissez-faire of groups. And I think this is what the Assembly Clause is really getting at. And a laissez-faire of groups, this is what Nisbet meant by that. He meant a variety of groups around a variety of purposes formed by individuals for all sorts of reasons. And laissez-faire, it implies that they compete with each other. Think of laissez-faire capitalism, competition in the marketplace. Well, these groups compete with each other. And what are they competing for? They're competing for the allegiance of individuals, for members. And what are they offering to these members? They're offering membership, communal value. And I think the really important core of any discussion of freedom of association or freedom of assembly is the principle of, write this down, functional autonomy. Functional autonomy. So the question is, are these free assemblies, are these free associations autonomous as to their function? This is a core theme in Nisbet's work. Are all of these associations, these social groups in society, are they free to perform the functions? And this is so important because the reason individuals form those groups, the reasons they form relationships and those social structures are for some function, to be able to worship God in the way that they see fit, to be able to take care of their neighbors, to be able to educate their children, whatever that function is. Can they be autonomous as to that function? Can they fulfill that function? Now, there's some more principles that I think are really important along these lines. But we can get into that a little bit later.
Great, thank you. One thing I'm going to want to talk about eventually is the CLS case, and of course, this more recent case, and some of these other cases that came before, the JC's case, the Boy Scouts case. It's really unclear to me after reading a bunch of these which groups have which rights and in which circumstances, and in which cases state governments can, through a non-discrimination law, kind of start to meddle with the membership requirements of organizations. So we'll get to all of that. But I have to say about Abby's work. So about 2 years ago, when I started really getting interested in some of these things, I started asking these questions about what actual value do we know that voluntary associations play, and what can policy do to help them? And then I read something that she wrote, and she was like 5 years ahead of me on all of this thinking. And so whether it's in National Review or some other work she's done for AEI, she's done this great thinking about how can these associations, what do they mean for community? What do they mean for social capital, but also political capital, economic mobility, and all of the good health of society that comes after that. So Abby, do you want to talk about those things, but also how policy can help them?
Well, thanks so much, Andy, for that really kind introduction, and for Manhattan Institute for hosting this program, and to be with you, Luke and John. I want to broaden our discussion a bit to what Andy said as we look towards policy solutions, because the right to assemble that we've been talking about is one piece of what social scientists call social capital, or the things we do together, which also includes things like family and work and our neighborhoods. And 3 quick points around that. The first is that we're living through the greatest collapse in social capital in modern American history. That when you look at the breakdown of the family, our historically low workforce participation rates, our increasingly segregated neighborhoods, the decline in face-to-face interaction we had long before COVID relegated us to things like Zoom. They seem at first glance to be disconnected, and yet they're all part of a broader phenomenon of individuals pulling away from communities. So the types of voluntary associations we're talking about, but in other ways of having relationships and communities too. And this was first made a mainstream point by Robert Putnam in his famous book, Bowling Alone. But since then, it's gained significant momentum and has reached all the way to Congress with the Social Capital Project under Senator Mike Lee. The second point is that this collapse in social capital has wide-ranging implications, as Andy alluded to. In fact, Robert Putnam's new book, The Upswing, tracks a decline in social capital along with any number of other various phenomenons, from our political polarization to economic inequality and stagnant mobility, showing that in some ways they're all braided together and intertwined, which of course makes sense to us, I think, hearing it, and yet that's not the way we tend to treat a lot of these issues from the policy perspective. So most of my work has been focused on the economic implications and on upward mobility, the ability of a generation of children to outperform their parents in absolute terms and relative terms, financially, economically speaking. And when you look at what types of factors impact those kids, neighborhood, family, schools, 3/4 of the ability of that person to rise out of their current socioeconomic status that they're born into has to do with social capital factors, the relationships that they have. And yet in Washington, we rarely discuss the types of community and voluntary associations and strengthening social capital as kind of the first lever to pull for solving some of these problems. Right now, we have the left continuing to focus on top-down solutions, and there's a lot to like about President Biden's plans, and yet there's no question that most of them are top-down and seek to recreate 1/4 to 1/3 of our GDP, depending on how you measure it. And on the right, a lot of our current discussion is more exclusionary. How do we define ourselves with who's left out as opposed to who's in? There's little attention on how do we strengthen the bonds that we have between each other and these bottom-up solutions. And so the third point, and then I'll stop, that I'd like to make is that this is an issue that policymakers can affect. And 2 questions really that I would encourage them to think about. The first is, does this policy create more space for our relationships with each other, more space for families and for voluntary associations and for work or less? And then second, can this policy be devolved to a more local, which is AKA a more personal, relational level than being done at the federal level, for example? So this has implications for policies, a wide range of policies, ranging not only from the tax-exempt status of voluntary associations, which John has worked so much for, but also paid parental leave and creating more space for parents to bond with their children, and earned income tax credit, strengthening a connection and a reconnection to work and charitable giving, and the list goes on. And so I'll just close with this thought that William Buckley has this great quote in a book now 30 years old that he wrote on calling for a national service program as a conservative. But getting to this point that conservatives historically have tended to really focus on this space between the market and between the state or the government. They've realized that there's something really special and powerful about our connections to each other that's been lost. And so as the GOP refigures itself and new factions are created in this season of significant kind of political turmoil, I would encourage conservatives to think through that and to consider at least making that a key part of their platform.
Well, we're going to talk about that a whole lot more toward the end, because this is certainly a passion of mine. It's a tough question. How can policymakers actually use their power to empower other people, especially in Washington, D.C.? How do you distribute authority so these voluntary associations, communities, and families have more power? And often policymakers don't think along those lines. They think along the lines of, how can I get power and make the world look like I want it to look? It's a different mindset to say, how do I use my power to distribute authority to a bunch of different people so they can do different things? But we'll come back to that. If you don't mind, what I'd like to do is talk about some of these seminal cases that really started to that form our current thinking about what the right of association and right of assembly are. And John, if you don't mind going first, I think the JC's case is probably the most interesting first one to talk about, because this is something that I think a lot of our viewers might be on their minds. What happens when a state decides that they want to pass some sort of non-discrimination law, and there is some sort of voluntary association that runs afoul of that? How do we litigate and then adjudicate those things? So do you mind talking about JC's?
Sure. I mean, and maybe a predicate comment is that anti-discrimination norms point out the fact that distributing power and voluntary associations and localism are not uniform goods, right? So there's a reason that states' rights can be a nasty term, and there's a reason that private voluntary groups of civil society have contributed to massive harms, and that there are sometimes limits on those groups. And the clash of association and assembly protections against anti-discrimination norms is one of the fields on which that tension plays out. In 1984, the JC's case involved this. Many people today don't even know who the JC's were, but back in the day, they were a kind of a civic association for young men to give them business training and networking skills. And the national organization wanted to remain all male, while the local organization wanted to admit women. So there are some pretty interesting and fascinating power dynamics here about gender norms and private spaces, but also how those norms affect commerce and social standing and even political access. In the case of the JCs, the court looked at those anti-discrimination concerns, weighed against what it for the first time recognized as these expressive association rights of the JCs. And one of the important takeaways from this case, Luke hinted at some of the consequences of not being clear about associational protections. And yes, there are all those groups that fall completely outside of expressive associations, but we should talk about those groups that are expressive associations, the JCs being one of them. In the Supreme Court, without really giving us a clear constitutional standard, said the JCs lose, even though the decision to exclude women for the sake of fostering this all-male community was clearly expressive and really important to who they were and what they did. The Supreme Court said the state's interest just outweighed it. And maybe that was the right decision in that case. I go back and forth on that based on my understanding of the facts, but the lack of clarity of a test or a reason for why it was the right decision then sets up several decades of cases that don't give us much direction.
Great, thank you. Luke, a big part of your book talks about the CLS decision, and this relates to a Christian group on a college campus, actually a law school campus, and the rules that they had for their membership and their leadership, which ran headlong into a university policy, and the student group lost. So can you walk us through that and why that's important?
Yeah, so this case in 2010, Christian Legal Society versus Martinez, the issue before the court was whether or not a public university, so this is a public university in California, could prescribe membership requirements for its official student groups. And traditionally, the court, when dealing with student groups at public universities, it had always said that they have First Amendment rights, right to speech, association, religious liberty. So religious groups have access to funding they can't be discriminated against by the university. And the court in this case basically said that the associational interests of the Christian Legal Society, I don't know, to put it delicately, didn't matter. It said that the expressive association and free speech interest merge, and so they would only consider the free speech issue. They decided that, of course, these students could still express whatever views they wanted. They just couldn't exclude people who didn't hold to those beliefs or didn't abide by the rules of the organization. So the language is remarkably dismissive of any associational concerns. So I see it as kind of I call it the reductio ad absurdum of this First Amendment dichotomy. So they say, can individuals still express themselves? Yep. Okay. Well, no concern here. And I think that's why that case is so concerning to those of us who care about associations and who wonder what rights ought to be protected under that assembly clause.
Great. We'll come back to some more of that a little bit later. So, Abby, imagine that political power changes in the next couple years. I don't know, maybe a Republican president comes to you. or a Republican majority in the House and Senate and says, listen, we have got to do something about community. For too long, these associations have been withering and we have to get Uncle Sam involved in some way. Could you give us a list of 3 or 5 policies that you think that we could do from Washington that could help these communities, families build social capital and thrive? What would be on the top of your list?
Great question. And I did think, being in economics, I was in the dismal science, but I'm starting to get depressed listening to Luke and John on the legal side. But on the policy side, I think we start where social capital is most built. And the primary unit of community is, of course, the family. And how do we strengthen the family, and what's the appropriate role of the government in that? I think one obvious area that I've dedicated a lot of time to is paid parental leave and creating space for a parent to bond with their child, no matter their income or their profession or where they live, that should be a universal benefit to protect that space and the beginning of really the most, intimate relationship in that child's life until later on. So I think, how do we strengthen family is a focus. How do we strengthen work is also a focus. I mean, COVID has decimated women's labor force participation, but prior to COVID, of course, it had plateaued since the 90s, and men's labor force participation has been steadily declining since the 1950s. And that's for a variety of reasons: increased education and retirement. But there's also this lack of workforce attachment among prime age men in the prime of their career, that we've never seen before. How do we reattach those men to work, which is not only financially important, but also where we find a lot of our meaning and dignity and purpose? And what concerns me is some of the current proposals, such as the minimum wage, would actually reduce or weaken the connection of those most marginally attached to the labor force relative to other policy solutions, like an earned income tax credit. That has a long history, going back to the 80s, of pulling people back into the labor force, because it's increasing the rewards to work, which means a lot not only for a family trying to make ends meet, but also means a lot for restoring a connection to something broader than oneself. And of course, I would encourage them to look at these voluntary charitable type associations. Are there a way we can bolster the personnel of those groups? Could we have a national service type program, but funneled through local organizations? How do we continue to protect the tax exempt status of these various groups? So I'd encourage those 3 buckets of work and family, and then kind of our voluntary life and associational life, and how do we strengthen those 3?
Well, you deserve a whole lot of credit on this because you're leading the charge on a couple of these points, but also over the past maybe year or 2 years, there's been more and more life on the political right thinking anew about some of these family and community policies. Like, there's currently a hot debate about whether family tax credits, child tax credits, or some sort of child allowance is the best policy for strengthening families. Many people use the argument that stronger families with more time and more money can be more involved in their communities. So this is a very live debate, and I hope we continue to pursue it in the years to come. Okay, I'd like to encourage the people watching to keep sending in questions. We already have a handful of great ones, and I'm going to go to one now. And Luke, you will be pleased to know that someone read your book and had a question that I had set up, but they set up better than I did. So just as background, there was a decision, I think it was called Smith, I don't know, maybe 30 years ago, that Congress ended up not liking and ended up passing in response to it. I think it's called RFRA, maybe the Religious Freedom Restoration Act. So this was an example of the court goes one way and then public sentiment goes the other way. And so Congress comes in and passes a law to, if not undo, then at least undermine the decision a bit. In your book, you come up with an idea for what would a legislative package look like to strengthen voluntary associations. I don't know if you would say to undermine some of these court decisions, maybe correct them, maybe move in a different direction. So would you just start to play out what that would look like, whether it's at the federal level or at the state level? That is, what can the elected branches do given what the courts have done?
Yeah, so as you said, there's a Supreme Court case in the early 90s, and there was kind of a public outcry against it because many people thought that it did not appropriately give enough weight to the protections of the Free Exercise Clause. So Congress passed the Religious Freedom Restoration Act, and a number of states have followed suit. So basically they said, well, the court has not read this right as broadly as we think it should, so we're putting in a legislative measure to make sure it's respected to the extent that we think it should. So you can't lessen the protections the judiciary has given, but you can expand them. So I wrote a draft of a piece of legislation, and it's in my book. And of course, I'd be happy to provide the text to anyone who's interested in it. And doing the same thing with the Assembly Clause and with the freedom of association. So the court as we've been discussing, has not been good on protecting freedom of associations. Defined it very narrowly. It's basically ignored the clause it really should be grounded in, the Assembly Clause. So through a piece of legislation, I think states or Congress could, within their jurisdiction, to the extent that they have authority over various matters, protect freedom of association. So that what the piece of legislation does is it, first of all, requires the government to consider associational questions under the Assembly Clause. It also requires that the government use strict scrutiny. What strict scrutiny is it's the highest level of scrutiny. And the court generally uses that level of scrutiny with free speech questions and free exercise questions. So the First Amendment, we consider it our preferred freedoms, and the court has said, well, then the government needs a compelling interest if it's going to infringe on these freedoms. And so what the piece of legislation would say is, within our jurisdiction, we expect our government officials and expect the courts to treat freedom of association, freedom of assembly with that same level of respect. And what it requires is, I'd use the term functional autonomy. So the question government officials need to ask, the question the courts need to ask is, are we impinging on the functional autonomy of this group? That's the primary question. There's some other questions that fit under that. For example, are we infringing upon traditions or practices of the group? Now, one really interesting question that comes up a lot with religious liberty are certain internal practices that from the outside seem entirely unimportant. Why is it important that someone has their hair a certain length or grows a beard? From the outside, it seems ephemeral. It seems like it would be easy to restrict certain practices or certain things without actually restricting the core freedom. That should not be above sharp question. Some of these internal practices that arise are very important to the integrity of the group, to its cohesion. It's things that people do together that are really important, these traditions that they have. So the piece of legislation would make sure that those elements of association are protected. I think it's a very helpful way in that something that legislatures can do to help protect freedom of association. And I think it has a secondary effect as well. If we have legislators introducing legislation like this and talking about it, it gives us an opportunity to talk about the importance of these associations. Why do we want to protect their functional autonomy? Why do we want to root them in the Assembly Clause? Because our constitutional clauses are really important, because these associations that we have are really important. And we're going to talk about them and put into our legislation that they matter. So it's one problem is a lot with talking about associations that they kind of have to be built from the ground up. Some of the policy protections or conversations sometimes are a little difficult because they do have to be great is to talk about their importance. And then of course we can get into a lot of other things we can do to help.
Great. Folks, please keep the questions coming in. We got another good one that allows me to pivot to something I wanted to talk about, given what John brought up about sometimes there being, we have to take seriously the downsides of localism or associations at times. And one thing I learned from your book, John, that I had never considered is I think you wrote that in earlier drafts of the First Amendment, I don't even think it was the First Amendment at that point, there was a clause that suggested that the assemblies had to be for the common good, but they ended up taking that out, the implication being this right has to apply to all groups, whether or not they are supporting the government or what other people think the common good is. So we have an idea that even distasteful groups ought to be protected. But on the other side of that, there are groups that can discriminate based on gender or based on race. Or one of the questions that came in is what happens if there are these groups like gangs that are planning crimes or planning an insurrection? How do we think about the protections of these groups, knowing they don't have to be for the common good, but also that if we don't monitor them, they could actually undermine a bunch of things that are important to the nation?
Yeah, there's a lot there in terms of interests we want to be thinking about. I mean, one thought quickly is I don't think we want to think about abstract categories of discrimination. So take gender discrimination. I don't think all gender discrimination is bad. The Catholic Church can make gender distinctions. A women's health club can make gender distinctions. Even on race, there's a Ninth Circuit opinion about a Hawaiian ancestry school that can make distinctions on the basis of race. And so sometimes we often want to look at context rather than abstract norms when we talk about government interests. the danger of criminal activity or conspiratorial activity is one of the fundamental tensions in criminal law. And the intersection of criminal law and the First Amendment takes us to the need for breathing space, even at some risk to stability and peaceful order. And this comes up in the protest setting, but it also comes up in sort of group discussion and formation. And the challenge here fundamentally is when you're talking about an inchoate or an incomplete crime, the people gathering to start to do something that may turn out bad, you don't actually know what's going to come next. They might end up doing something bad, or they might end up deciding differently and going and grabbing a beer. And so without knowing what's going to happen, it becomes difficult to figure out how you criminalize it. And so we need to do some hard work about thinking how we monitor and constrain the most dangerous pre-criminal activity. We're not going to let you form the local chapter of Al-Qaeda to talk about ideas. So there are some limits there. But in many cases, we have to protect the informal aspects of the group, even when they seem to us like they might be dangerous or concerning. And here is where I might slightly disagree with some of Luke's emphasis on the functional analysis, because the way that we actually deepen bonds in many groups are in non-functional settings. They're the informal meals or the social gatherings or the things that seem secondary or derivative from the fundamental purposes of the group. But that's where we deepen the bonds and sometimes brainstorm and discover ideas. And I think too much of a functional focus, although I like where Luke is directing us, but too much of a functional focus to the neglect of the informal can lead to some underprotected areas as well.
Would you mind just as making sure that all of us, especially non-lawyers like me, understand the distinctions here? So as my understanding is that sororities are legal. You can, there can be gender-based differences on fraternity sororities. But in the VMI case, it was decided that VMI couldn't remain all male. You raised this question of the Hawaiian case, like a school that could have this racial discrimination. But I think there was also a case related to a Christian university, Bob Jones maybe, that had tried to ban interracial dating, and the IRS took away their non-profit status because of that. So are there rules of thumb the court is currently using for when discrimination based on these historically marginalized categories, whether it's gender, race, something else, when it's okay for groups to do it and when it's not okay for them to do it?
Yeah, I mean, it's interesting. So there are some very general constitutional tiers that the court attempts to slot certain forms of discrimination within, although it's not entirely clear about what those are or why they are. I think the one thing we can say with some confidence is that discrimination against African Americans has been the one area where the Supreme Court has been most willing to pull back and sometimes level the protections for voluntary associations, because in the Jim Crow era and the eras that preceded it, it was in fact the voluntary associations that were propping up much of the discrimination against African Americans. But when you look at the constitutional doctrine that emerged there, it just doesn't translate well to other contexts. And in most other contexts, we have much greater associational protections. And so I think one of the real questions, and you hinted at this in your question to me, one of the most important questions to come is, do we as a country today, judicially, legislative, and otherwise, think of discrimination against African Americans as a singularly distinct harm and governmental interest than anything else? Or are there other forms of discrimination or government interest that fit into that category? And that's where a lot of the debate in the academy and in other parts of the country is today.
Got it. Abby, I want to turn to this federal policy question again, because the Biden administration, whether you like it or hate it, they have been active in their first 100 days or so. And there has been a joke going around on the internet about everything is infrastructure. Paid family leave is infrastructure. Child allowance is infrastructure, whatever else it might be. But it does raise the question of what are the kinds of things that are part of the Biden administration's big agenda on more federal activity that people who are caring a lot about community building, especially Uncle Sam's role in it, ought to have an open mind about, that we shouldn't just be partisans and say, that's actually interesting. Maybe it's not a bridge or a road, but maybe that thing in there is a good idea, or some of his other family policies. Anything you want to single out?
Sure. The semantics of what's called infrastructure, I really, who does care besides Twitter and things like that? I think any good economist would tell you that a growing and flourishing economy requires robust physical capital and robust human capital. And human capital is the types of things we're talking about: education, skill building, relationships, healthy families. And so I don't fault him for including both. And underneath, I'm sure, a word like infrastructure that polls really well is politically astute. In the particular package, however, most of the priorities are pretty progressive and don't hoe a lot of the common ground that we've seen be created on these issues, especially on family policy and work. So, not to repeat myself, but to repeat myself a little bit, when we think about how to increase work, the bipartisan consensus, and I think the academic literature is much more supportive of a type of wage subsidy like the EITC, as opposed to a higher minimum wage. Biden's plan leans more heavily towards a higher minimum wage. When we think about family policy, there's a lot in there that actually increases the choice of childcare providers. And, if you have it's essentially a childcare voucher that families can use up to $8,000 if they want to do a Montessori school or do a language program or full-time center-based care or a nanny. There's a lot of flexibility in there. That's the type of thing that I think we should encourage. But then there's universal preschool for 3 and 4-year-olds. And when we talk about social capital, I feel like that negates a lot of the research that we know about the importance of children being with their families and the families being able to provide a really stimulating and engaging environment for a lot of families. And for those who can't provide that, then it makes sense to have other options, which of course the child care voucher gets to, but to try to put everybody into, a center-based care that's full-time as 3 and 4-year-old, I don't think that strengthens the family. I'd much more lean towards the other provisions where he has to increase the flexibility of childcare providers or by lifting wages with something like a wage subsidy, right? You allow maybe parents to work less hours and be more home with their children than they might have otherwise been able to, or to be on one income. And so, again, I do think thinking through how does this affect families and work and our relationship to each other actually cuts through a lot of the semantic crap, for lack of a better word, or the partisan lines, because it doesn't fit neatly into either camp, at least as they've currently pitted themselves. And so I think it's a really helpful lens to think through what policies make sense in our current environment when families and work and all these areas of our associational life are so stressed and fractured.
Great, thank you. One final pitch for anyone out there watching. Please keep sending questions in. They've been great. I want to make sure before we come to a close, we probably only have about 10, 15 minutes left. I want to get to this important California case, and then the broader issue of what this current makeup of the U.S. Supreme Court, how you think they might think about these issues generally. So maybe, John, would you mind giving us the outlines of this case related to the donors that are giving to nonprofit organizations and whether or not they can remain anonymous, or if the state can actually get that information and what it can do with it? So what are the details of that case, and then why is it important? And then Luke, I'm going to come back to you and ask about what we think about this current court, given that they've been so good or they've been respectful of religious liberty. Do we think that that's going to expand to associational or assembly liberty as well? So John, what's this California case?
Sure. So the California case involves the California AG's office wanting to get the 990s, the full 990s of nonprofit organizations, including listing key members and donors that can usually be protected or anonymized. And then there's a problem, a derivative problem where the office was leaking or being infiltrated so that those were released to the public. And so these donors were saying this is going to have a chilling effect on us, on our support for organizations. There'll be consequences for this, not unlike actually some of the similar themes that were raised in the original right of association case involving the NAACP. When those membership lists were leaked, there were far more dire consequences, and people were attacked and assaulted in public because of the affiliations. And so there's a theme that runs through the desire to have some protections anonymized. And what's interesting here in this case and others is how you get broad coalitions of people who usually disagree with you. So when you look at the amicus briefs in this case, you have very left-leaning groups and very right-leaning groups all saying, this is a bad idea and we need stronger associational protections for the private groups of civil society. It's important to have a kind of associational privacy. And I think, for policymakers out there, I think when you can find or identify issues that legitimately, and not just in a token way, but legitimately help protect the people you don't like, then I think you're, as well as yourself, then I think you're onto something that really falls within the basket of civil liberties. And this case and others like it remind me of that benefit and opportunity. I mean, just quickly, Michael McConnell and I did a brief a few years ago in one of these cases representing religious groups, and we represented in the same brief the Catholic bishops, the Southern Baptists, and the Hare Krishnas. And anytime you can get them to agree on anything, you're talking about something of general interest for the good of all of us. And those are the kinds of issues that this case raises.
And Luke, what I alluded to earlier is there have been a series of cases over the past, decade, but especially picking up recently, like with Espinoza, where it seems like this court is recognizing the value of protecting religious organizations, and especially with Amy Coney Barrett now on the court, and some people say a 6-member conservative bloc. Do we think that that's going to lead to change in their thinking about what the freedom of association or freedom of assembly looks like? Or is it going to be more of just standing on the precedents that we already have?
Oh, that's a good question. I think it's we have a good chance that they'll be able to recognize the value of freedom of assembly, thanks to John's work over the last decade. At least there's chatter about freedom of assembly, and there's a great amicus brief submitted that references John's work and references the Assembly Clause specifically explaining its importance. So the court, kind of one problem with talking about freedom of association and all these things is the court does have precedent that's not helpful on this matter. So the fact that the court has been so protective of religious organizations, it is a good sign. Also, one thing some people have been talking about, especially regarding this particular case that the court is looking at right now, is thinking about how religious organizations often form the pattern of behavior that other social groups have. So we do tax exemptions, for example, for religious organizations, charitable organizations, and educational organizations. Educational and charitable organizations were often religious. They, of course, don't have to be, but they kind of gain a certain aura from and protection from their origins and religious life. It provides kind of a pattern for how we think about these social groups, even when they're not religious, in terms of the protections that they have. So I'm hoping that the precedent that they've built over the last decade and beyond might be helpful in getting them to think about non-religious assemblies. They've been good in thinking about religious assemblies, and can they make the jump to just thinking about that assembly clause? And I think we have a good chance right now, as we've had in a long time.
Great. In the last few minutes here, before I ask for your closing statements, is there anything that any of you have heard one of your colleagues say that was particularly interesting, or you want to dig in on, or even better, disagree with, so we can get some fireworks in this thing?
Well, I'll raise a point that I had a conversation offline with John about all of this, and obviously I don't presume to be a legal scholar in any means. And, when we're talking about either from the economic side, the tax protections for a variety of different associations, or the legal protections, it does strike me that both our politics and policymaking is downstream of culture. And what seems to be the bigger threat for the diversity of associations and the types of things we're talking about, even if you talk about norms for family and work and neighborhoods and the rest of it, is the kind of culture that we're in. And is it supportive of a lot of these different types of organizations, or potentially irrespective of what legal and tax exemptions are in place, that there's a broader cancel culture, I hate to use that word, but a broader culture that makes it really hard to be part of these different associations or hold these different beliefs. And, that really is outside of a lot of what we can control, or the levers we like to toggle with in the policy world or the legal world. And yet I feel like could have really significant, even more significant ramifications for the future of these types of organizations.
One thought I had listening to Abby and just trying to think of people in the audience and how you wrestle with different things is, are there ways in which you can imagine your own view of the good or your own structure of the good in ways that also encompass or allow for other forms of pursuit of the good, including those you might think are not so good. And so even the family structure, are there policy proposals that could broaden protections to larger groups of people that are family-like, maybe not in the way that you see family, but in ways that can encourage close friends to have certain benefits together that could benefit the structure or the forces of being together in a household? And are there resources within your own traditions that might actually view those different in an imaginative way that could allow for your own greater flourishing, your own greater pursuit, as well as for others to do things differently? It's going to require a kind of imaginative bridge building, but I think there may be opportunities when we step outside some of our own views of what we think is right to think more broadly.
Great. Luke, any thoughts?
Oh yeah, I agree. I think when we're talking about freedoms, and especially associational freedoms, it is important to think about the categories that protections for ourselves, but to have empathy for people we disagree with. A lot of times when we see religious practices or some things that seem very much outside of our experience, it strikes us as weird, or it strikes us as unimportant, non-essential, or something like that. And instead of having empathy, have somebody from a different culture viewed what we do on a weekly basis, or the certain practices we have in a broad sense, they might have the same feeling. In what ways can we be as empathetic as we can to people who are different from us, who might want associational protections, say, that seem unnecessary or even damaging? But what ways can we be as open as possible to what they're trying to do? John had mentioned at the beginning that kind of ironically, it's kind of by embracing our differences, we might find common ground. And it's an important point of, some of the a devout Muslim and a devout Roman Catholic, very different things, but they might, in their devotion and in the need for free exercise protections, for perhaps religious exemptions and these sorts of things, see common ground that they have. Yeah, we have some very disagreements, but we kind of, in this form and structure, we have similar concerns, and we can build bridges. One of the most moving, I think, memes that came after the tragic shooting at the Pittsburgh synagogue was the Muslims holding the sign of, "We'll watch you pray," something like that. Believe the Jews in the synagogue, the Muslims be very different things, but they both want to pray in peace and safety, and they can agree on that, and they can come together on that. And so that sort of bridge building of thinking creatively about that. I think that's exactly right. Take tax exemptions and religious exemptions and these sorts of things. How can we be as broad as possible, as accommodating as possible to our other members of our community, broadly understood, especially ones that are outside of our immediate experience? I want certain exemptions because of my religious views and my social understandings, but I bet there are people who want exemptions that don't make any sense to me. And how can I be as tolerant to them as possible? And that's what we should be thinking about as we approach these issues.
Yeah, if I can just do a little bit of editorializing before giving you all the chance to summarize, is the federal work that I've done, especially recently, I have found that because of American, just our polarization, there is this sense that sometimes pluralism is to be opposed, that it's us against them and we have to win, or they win and they're going to do harm to us. But that kind of Washington, D.C. federal conversation still seems to be different than what I'm seeing at the state level. There are a lot of states often that if they have counties or municipalities, the state legislature will defer to a city, a county, and allow them to have like a county, a municipal bill that the state's not going to get involved. If you want to increase your property tax by that amount or change your zoning by that amount, we're going to trust you to do that. So I still think looking at state policy that people appreciate pluralism a good bit. What I get concerned about is the national conversation, that we just have less and less civility and accommodation for what I was taught was essential to America, e pluribus unum, that, yeah, we do come together, we're one, but that is based on this idea that there's this wide difference in traditions and histories, and we have to respect those. So all of you are welcome to comment on that, tell me why I'm wrong, or just take a minute or so to say whatever you want to end on. Abby, maybe we can start with you.
Sure. I think when you think of policymaking, a lot of people use the majority wants this as a reason to do things. And there's nothing special about having a majority rule country. What makes America special is the protection of the different minority viewpoints. And so I think that's really important to keep in mind. And then from a policy standpoint, how can we strengthen our social fabric, not only thinking of it stovetyped between, work and family and voluntary associations, but thinking of this as one big social capital phenomenon and how to strengthen it from bottom up. Those are the two things I would leave the audience with.
Thank you. Luke?
Yeah, well, I think we can talk and think about our associations as the importance that they deserve. So sometimes we talk about associations in terms of benefits they might provide, instead of the very substance of the lives that we live. So it comes as no surprise at all to me that people with more social capital, that is, people embedded in these associations, are more likely to succeed. In fact, that explains the vast majority of individual success. Makes perfect sense to me, given that associations are really the substance of our life. From the time where we come into this world, we're part of an association, and our success will be dependent upon the associations we have in our lives. So seemingly unimportant associations like this motorcycle club that John mentioned, for the people in that group, that might be the most important thing in their lives. Those informal conversations they have when they go on trips together, the jackets that they wear with the slogans on it, living to ride, ride or die. That's, these sorts of slogans that they had. For them, that's important around their friendships and around the real substance. We know that people without those sorts of groups are the people who have more likely to have deaths of despair and that sort of thing. So these groups are the very substance of our lives, and that's true for everyone. So Abby just mentioned, now let's be a little concerned when we say the majority wants. When we're talking about associations and associational protections and associational interest, we're talking something more about a universal interest. I have a slogan I'll use when I talk about this. I'll say, social groups of the world unite. When I talk about associational protection. So we all of us in our associations have these interests as associations, and it's really the substance of our life. And I think we should talk about them that way, and legislators should talk about them that way. These are where the lives lives, and we want them to thrive as much as we possibly can.
Great. John, bring us home.
Sure. Well, we've talked a lot about law and policy, so end with a reminder of citizenship and humanity, and just encourage all of us to take a practical step to reach out to somebody across difference, and maybe even talk about this idea and why it matters and why the differences matter. The bar right now, coming off of a pandemic and our social media habits, is going to be so low that if you practice basic social skills and hospitality, they'll go a long way. So don't forget the human side to all of this as well.
Well, what a great way to end. So I had such big expectations. I was really looking forward to this event, and you guys were terrific. Thank you. I learned a whole lot, and I hope our audience did too. And so thank you for the audience for joining us for this. If you like what you saw, you can subscribe to future Manhattan research, but also events like this through the link that's in the chat box. You can also, if you'd like, use that to make a donation to Manhattan. Remember, we're a nonprofit. We're one of these mediating institutions, and our research and events are dependent on great folks like you. So again, thank you to our wonderful guests and everyone who tuned in. We hope to see you all soon. Thanks, John, Abby, and Luke.
Thank you.